So now we want to take a look at the South Carolina Residential Landlord and Tenant Act. And obviously before we even get into it, there's some things I want to make sure we're clear on. Might help resolve some questions before you even think about it. But one, again, this is the South Carolina Landlord and Tenant Act. Could other states do some things a little bit differently? I promise you they do. So this is just what you need to know for the South Carolina portion of the exam. But then I also want you to notice, it's the South Carolina Residential Landlord and Tenant Act. Nothing in this law that we're getting ready to go over pertains to commercial properties. All right? So don't even be thinking commercial. So if you're a tenant leasing commercial property or a landlord leasing commercial property, this law does not apply. This is just for residential leases. All right. So first thing we look at are what the law says in terms of the terms and conditions of a rental agreement. Some things the law says you can do or can have. And basically, according to the law, that we can have, or a landlord can put anything in their lease that they want to. Obviously, as long as it's legal. Okay? So as long as it's legal, we can put anything in there we want to. Regardless of how stupid or ridiculous maybe the tenant may feel like it might be. In paragraph B, saying the tenant will pay fair market rent if there's no lease. What they're saying here, apparently there are some that have signed leases even though the lease never stipulated how much the rent would be. And for that reason, they had to put in the law. If you do agree to sign a lease and it does not include a rental amount, then the rent will be whatever the fair market rent is for that area. That's kind of ridiculous, but I think it'd be a whole lot easier. Just put the rental amount in the lease and then there's no problems. I like paragraph C, where it says rent is payable without demand at the time and place stipulated in the lease. Without demand means I shouldn't have to come asking for the rent. Where's the rent? When are you going to pay the rent? I will just tell you, me personally, really not an issue, because I make it very clear. You will not be late, and I will not be coming asking for the rent, period. And it says right here in the law, I do not have to ask for the rent. I can actually kick you out, believe it or not, if you don't pay and if you don't pay on time. And then paragraph D, again, another kind of a ridiculous provision here in the law as far as I'm concerned. But if it does not stipulate in the lease how often the rent is due. I think most people would agree or understand that rent's usually due on the first of every month. So you'll have like a month-to-month tenancy there, meaning you got to pay the first of every month. But in case you have in case you forget to agree to that or it doesn't state that, then the law says then the tenant would have to pay week to week. It also indicates here that if you're going to have a roommate, and assuming you charge the roommate rent, then the roommate would have to also pay week to week. Okay? Unless there's some other written agreement. Again, at the end of the day, it should state in the lease, here's how much rent has to be paid. Here's when it has to be paid and how often it has to be paid. It just seems like it'd be a whole lot easier if we just agree to that in the lease, but there you go. This next section is dealing with the effect of an unsigned or undelivered rental agreement. And basically what they're talking about here, say for example, a tenant is wanting to rent this apartment building or a house or whatever it is, they want to rent this residential area or property. They sign the lease. The tenant does. Tenant signs the lease. They pay their security deposit. They pay their first month's rent. And the person there that they're talking to actually turns over the keys. Said, all right, well, we look forward to having you here. Here's the keys to the property, so you can go ahead and move in. Now, the property manager is actually out of town this week, and but he or she, whoever it is, they'll be back on Monday. And when they get back, they will also sign the lease, and then we'll get you a copy of it. But that'll be Monday or first part of the week. But again, you can go ahead and move in. Well, y'all, do we have an enforceable lease at that moment? Is it enforceable? And the answer is it is. Because y'all, and we actually talked about this during the contracts chapter, if you recall, or at least in an earlier chapter, we talked about this. But there's actually one type of contract that can be oral and still be enforceable in court. And that would be an oral lease for 1 year or less. And that's what all of this is saying. You can certainly read it, and hopefully you will. But the main thing you need to understand here, oral leases for up to 1 year. They're just as enforceable as any written lease. The fact that the tenant paid their first month's rent, the other party accepted it, then the other party turns over keys to the tenant. What keys represents possession. We now have an agreement, whether the lease has been signed or not. So in reality, as long as the landlord comes back within the year and signs the lease, then you've got a valid and enforceable lease. So I'd remember that. Oral leases are enforceable for up to 1 year. All right. Then the law identifies some of the prohibited provisions in a rental agreement. Obviously prohibited means things you're prohibited from doing, or prohibited in this case from putting in a lease agreement. Number one, you cannot have the tenant agree in the lease that they're waiving their rights or remedies in case there are issues, maybe even legal issues. You can't have them agree in the lease that they can't sue or won't take action against the landlord if the landlord's not doing what they're supposed to do. You can't do stuff like that. Even if you put it in there and they agree to it, the courts will not enforce it. That's something they would consider to be unconscionable. Number two, it says you cannot authorize any person to confess judgment. You can't try to push or persuade a tenant to accepting responsibility for something that was not their fault. That's a no-no. 3, agrees to the exploitation or limitation of any liability of the landlord arising under law or to indemnify. This kind of goes back to what we were talking about there in number 1. Again, you cannot have the tenant agree that you won't sue me if the landlord's doing something illegal. You can't do stuff like that. And then 4, you can't have provisions prohibited by this law, right? If the Landlord and Tenant Act says you got to do this, then you can't put it in your lease that you're not going to do this, or vice versa, right? We got to comply with the law. At the end of the day, you can't have just dumb stuff in your lease, which basically would require the tenant to waive their legal rights. You can't do stuff like that. And again, even if you do, and even if the tenant agrees to it, it's not going to be enforceable. Okay. Now we look at what the landlord's obligations are under this act. And the first thing is saying here in paragraph A, again, any deposits, and we kind of talked a little bit about this if you recall, dealing with earnest money, or trust funds rather. We know security deposits are considered trust funds, obviously, so all this is supposed to be kept in a trust account anyway. But A is saying that you must return these deposits within 30 days of the lease expiring. I would remember that. Within 30 days of that lease expiring, you better return their deposit. Now, it does say, unless they've caused damage to the property or you have some legal, valid reason to withhold some of that deposit, then obviously you can withhold it, whatever you're legally entitled to, but whatever is left over, again, it has to be returned to the tenant within 30 days of expiration. Now, it also says here in the same paragraph A that if you are going to withhold, deduct some of that deposit, then it's got to be an itemized list. You just can't say you've caused, you knocked a hole in the wall, you tore up the carpet, you did this, you did that, and we're going to keep $700 of your $1,000 deposit. You cannot do that. Again, it has to be itemized. You got to break it down. And by the way, you can only withhold whatever it cost to repair. So if you're the landlord, you better be keeping receipts showing what you paid to repair whatever damage that was directly caused by the tenant. And then you itemize that, add it up, and then whatever that total is, you can withhold. But whatever's left over, again, you got to send that within 30 days with a list of the itemized deductions. So there's no question what you're withholding that money for. And then it also says here that, landlord, you must provide the tenant with your forwarding address. And and I think a lot of people just assume that would just be like the office address. And, there's nothing wrong with having an office address. But what if something happens, what if something happens after business hours and there's nobody at the office? The tenant has the right to know who they can come see and where they need to come see them in case of an emergency. And I think you're going to see something. In fact, I know you are. We're going to see that again in the law. Actually, you know what? That part, everything I just said is true. The landlord does have to provide the tenant a forwarding address or an address that they can come to 24/7. But that's not what they're referring to here. I apologize. Misread my own slide. But it says tenants must give the landlord their forwarding address. So when the tenant's moving out, the tenant must provide the landlord with the address of wherever they're moving to. Because I know for me, I never allowed tenants to pick up, come by the office and pick up their deposit. I never allowed that. I insisted you better give me a good forwarding address because that's the only way you're going to get this money. It will be mailed to you, and it's going to be mailed to the address you give me. Just in case something comes up in the future where now I need to find you, I want to know where you're going. So tenants do have to provide what their forwarding address is. That's what they're referring to here. So my apologies, didn't mean to confuse you. And then in paragraph B, if the tenant feels like the landlord has unlawfully, illegally withheld more money deposit than they should have, obviously that would be reason to take the landlord to court, go to magistrate's court, and assuming they can prove that this money was unlawfully withheld, the law says that the tenant can now recover up to 3 times whatever that wrongful amount that was withheld would be. 3 times. That could be a little bit costly there. So that's the landlord's obligations. Here's this disclosure I was mistakenly going over on the previous slide. But this is where it says in the law, the landlord must provide the tenant with the landlord's name and address. Y'all, and again, not just the office address. Y'all, the tenant has a right to know where you are. Y'all, the way I would interpret this is, y'all, landlord, you have to provide your home address. In case of an emergency, the tenant has a right to know where they can come find you. Okay? So you got to provide the tenant with your name and address in case of an emergency. This next section identifies what the landlord's requirements are in terms of maintaining the premises. Y'all, obviously by law, landlord, you have to maintain the property. And you see what all that might consist of. But y'all, you got to comply with housing and building codes. You got to make repairs. Things break, got to fix it. Now, tenant, if you tenant, if you break it, then tenant, you're going to have to fix it. But if something just wears out or breaks on its own, and those things happen, then landlord, you have to make those repairs. 3 says they got to keep the property in habitable condition. Y'all, duh. 4 says they have to make available water and reasonable amounts of hot water, and then also maintain utilities and appliances. Now, y'all, I pay attention to that last one, where it's talking about appliance. You got to maintain appliances. Y'all, oftentimes, and you'll hear this from landlords, say the refrigerator breaks, quits working. And obviously the tenant's wanting to get the refrigerator fixed or replaced, whatever needs to happen there. But a lot of times you'll hear the landlord's response is, well, no, we're not fixing the refrigerator. The refrigerator is personal property. And that refrigerator, it was just there, and certainly you can use it, but we're only leasing or renting real property. We're not responsible for maintaining any personal property, y'all, like some of these appliances. And y'all will tell you that's a violation of this act. Now, does the landlord have to provide a refrigerator? Y'all, does the refrigerator have to be in the property? No. Because again, that is just personal property. But what the law is saying, but if the refrigerator is there when the tenant signs the lease, then landlord, you're going to have to maintain that refrigerator for the duration of the lease. So, just to make sure we're all clear on that in case they try to ask you a question about appliances or personal property. Again, they don't have to provide the personal property, but if it's there or if they do provide it, then they do have to maintain it. You can't say, there's a refrigerator there, but if it breaks, I'm not fixing it. Landlord, if you don't want to fix it, you better take it out of there before you sign that lease. All right. Then we look at what the tenant's requirements are in terms of maintaining the premises. And it's pretty much the same thing as the landlord's. And as far as I'm concerned, it's all common sense anyway. But let's look. Tenant has to comply with both housing and building codes. They got to keep the property clean, dispose of their garbage, haul it off, whatever needs to be done. They got to keep fixtures clean, maintain all their systems. You cannot destroy or damage any part of the premises. You cannot disturb other tenants. And you must comply with all the terms in the lease. I think everything in there is probably common sense. I doubt anybody would be shocked by any of those requirements, but there they go. That's what the tenant's required to do. But now we take a look at, when can the landlord legally have access to the property that's currently rented to a tenant? When can they legally go into the property? Well, in paragraph A, basically it's saying, you can go in any time with the tenant's consent. Now we're going to talk some more about that in a little bit. But basically A is saying, the tenant cannot be unreasonable about withholding consent. For example, if I should contact one of my tenants about wanting to come in and do an inspection to make sure it's being maintained, taken care of, which I have a right to do. So I'll contact the tenant and trying to schedule a day and time that I can come and take a look at the property. Well, what A is saying, tenant, you have to schedule a time. Okay? I'm trying to work with you here. I'm not just going to show up. But you have to agree, at least set a time and date that it would be okay for me to come in, and here by law, you cannot unreasonably withhold that consent. Now, when they talk about unreasonable, now landlords, should you be calling them every week wanting to go in and inspect? No, that might be a little bit unreasonable there. But from time to time, I do have a right as a landlord to make sure my property is being maintained and taken care of. So tenant, you have to schedule a time with me. Now in paragraph B, what it's saying here is I can go in, well, this is where it's actually number one saying anytime with the tenant's consent. If the tenant, once the tenant says okay, then I can go in. But then in B2, is saying I can, I'm kind of paraphrasing here. You can read exactly how it's worded in your book. But I can go in anytime between 9 a.m. and 6 p.m. if it's for a regularly scheduled visit. For example, in my leases with my tenants, one of the things I would have in, and again, this is in the lease, where it might say on the first Tuesday of every quarter, my bug guy is going to be coming out to spray for bugs. Now, first of all, I would think if you're a tenant, you'd appreciate that. But even if you don't appreciate it, it really doesn't matter. They're coming anyway. And I've got it in the lease when they're coming. On the first Tuesday of every quarter. They're coming. Now, tenant, if you would like to be home or present while my bug guys there doing their thing, then obviously you need to schedule your time accordingly. But I just want to be clear, tenant. If they show up between 9 a.m. and 6 p.m. on that first Tuesday of the quarter and no one's there to let them in, they will let themselves in. I give my contractors a key to every property just in case something like this should happen. So they will let themselves in. And I can do that. Again, law says we can go in anytime between 9 and 6 if it's something that was originally scheduled. And I've got some, like my heating and air guy is going to be coming out twice a year to do preventive maintenance on the heating and air unit. So they're coming. So I'm just letting you know. Now, to try to accommodate, try to make things as easy as possible on the tenant, what my contractors will do, maybe a couple of days or so before that Tuesday, they'll contact the tenant and let them know, hey, look, this coming Tuesday is when we're scheduled to come out and spray for bugs. I just want to make sure there's no problem with that. And look, and if there is a problem, whether they got company or there's some reason why they don't want to do it on that Tuesday, then we can reschedule. We can do it the next day or a little bit later in the week or whatever. But as long as the tenant is working with my contractor, because we're going to get it done, we're not just going to try to force our way in, right, if it's not convenient. But we do give our tenants at least a heads up. But then in B3, it says I can also go into the property anytime between 8 a.m. and 8 p.m. if it's for something the tenant specifically requested needed to be done. And I don't know what it is or why this is the case, but it does seem quite often, tenants will call about some problem that needs to be addressed or something needs to be fixed. Then I'll contact my contractor to go out to take care of it. And when my contractor gets there, the tenant has left the property. They're not even home. So the way I fix that, y'all, this is one of the reasons I give all my contractors a key to every one of my properties, so they can let themselves in. And in this situation, if it's something the tenant called me and asked me to take care of, now my contractor they can let themselves in anytime between 8 a.m. and 8 p.m. So look, why they have to have two different sets of times like this, I really don't know. The only thing I can assume is they're trying to cause you problems on the state exam. That's the only reason I can think of, to have two sets of times. But they do have two different times, so you might want to keep them straight. They could ask you about it. But again, it's from 9 a.m. to 6 p.m. if it's a regularly scheduled visit. Anytime between 8 a.m. and 8 p.m. if it's something the tenant specifically requested, I have somebody come over and take care of. Okay. Now, paragraph C is just saying, do not harass the tenant. You cannot do that. Y'all kind of like what I was saying earlier. You can't say call them up every week saying you're coming to do a surprise inspection. You cannot be harassing the tenant. In paragraph D, I make sure my tenants know this, but tenants, you cannot change any locks on any doors. That includes both interior and exterior doors. There's been times when my contractors or sometimes even myself have gone into the house and there'll be a bedroom door that's locked. And I will tell you, I don't even have locks on any of my interior doors. And there's for reasons that y'all put locks on there, doorknobs without any locks. So when I see a doorknob on that bedroom door that's not with a lock, then obviously I know you changed the doorknob. You changed it because that wasn't there when you moved in. And I will tell you that will get you evicted. And I tell my tenants that. I better not be denied any part of that property if I need to look at it or if I got a contractor trying to take care of something. I'm not going to put up with locked doors that I can't and my contractors can't get into. Got a problem with that. All right. Now we look at what the tenant's remedies are in case the landlord is in non-compliance. Say, for example, something breaks. Obviously, tenant, you notify the landlord, but you'll notice it says here, tenant, you must notify the landlord of the issue in writing. Rarely do tenants ever notify the landlord in writing. If anything, they'll call them and tell them about the problem, and they never put anything in writing. The law says it has to be in writing. So I'd pay attention to that. But then it also says landlord now has up to 14 days to remedy the problem. To fix whatever the issue is. Now, let's talk about this for a second. First of all, why does it have to be in writing? And by the way, that's not a suggestion. That's in the law. It's got to be in writing. Because, and this is sort of part of the law that we're not really getting into because it's not testable for whatever reason. But, as a landlord, the landlord's required by law to maintain a complaint log, where basically the tenant notifies me of an issue in writing, then I can file that written complaint into my log, and on the register I put on there, complaint received on September the 3rd at 9 a.m. But then you must also have on that log, then what did you do about it and when did you do it? So I might have on there at 9:30 a.m. on the 3rd, I contacted my contractor to go out there and take care of it. And then when the contractor notifies me that they're finished, they've taken care of the problem, then I'll close it out. Whatever time contractor fixed the problem. And you got to keep a written record of those type things. Again, this is not a suggestion, it's required by law. Even though, just because most landlords don't do it, does not mean it's not required to be done. Now, here's the other issue that I want to make sure you understand. I've actually heard and seen where a lot of landlords wind up getting sued by the tenant. They wind up going to magistrate's court, and the tenant is basically claiming that the landlord did not fix something when they should have fixed it, and the landlord's claiming they did fix it. In fact, right here, I got proof right here, Judge. I fixed it within the 14 days required by law. And the magistrates still rule against the landlord. And there's a reason for it, because we're misinterpreting this provision of the law. And you need to remember this for test purposes. I've had people come back telling me they got questions that caused them a problem on the exam about this. If they should ever if they ask you on the exam, how much time does the landlord have to remedy any problems or issues? If one of your options is up to 14 days, then that's the option I would choose. But what people are telling me is that's not even an option. And the reason for that is because the right answer is immediately or as soon as possible. Again, the law is saying, landlord, you have up to 14 days. That should not be interpreted to think that you can wait till day 12 to start working on the problem if it's something you could have fixed the same day. Right? You got to go ahead and get it fixed immediately. The only reason they allow you, say, up to 14 days is maybe say your heating and air goes out and the HVAC company says, well, we're going to have to order some parts, and it might be a week, 10 days or so to get the part in. And I will tell you, that's not unusual. So that's why they give you up to 14 days. But if they determine that it could have been fixed a lot sooner than what you fixed it, you're going to have a problem when you stand there in front of that magistrate. So just keep that in mind. Here we talk about what happens in case of failure to deliver possession. First of all, how and why would that even happen? Let me give you an example. This hopefully will make more sense to you. But let's say I've got a lease on a property of mine that's actually expiring the end of this month. So roughly another 3 or 4 weeks, the lease is expiring. And the tenant's already told me that they're going to be moving on. They're going somewhere else. They're not staying. They're not going to renew the lease. Typically, I want to know this usually 30 days out so that I can now start looking for another tenant to move in soon or right after this tenant moves out. Because I don't want the vacancy days to add up. The more vacancy you have, the more money you're losing, right? So I'll be looking for another tenant. Well, let's say I find another tenant. They like the house. They've said, I want to rent it. As soon as they're out of here, I want to rent. Well, the way you hold the property for that tenant, the tenant will usually do at least one of maybe a couple of things here. Typically, to hold the property for that tenant, they'll usually put up the security deposit, and will most likely go ahead and sign the lease, right? And obviously the lease will go into effect, the first of the next month or whenever. Then that guarantees that property for that tenant, right? Now, this is where a lot of landlords make a huge mistake. They'll go ahead and sign the new lease with the new tenant and make it effective the first of the following month. Well, the lease that's currently there, it doesn't expire until the 30th, and now you're thinking the very next day? You think another tenant's going to be able to move in? That's not even reasonable to think that. In fact, I will tell you, rarely, in my experience, is the tenant that's leaving, they hardly ever get out of there by the 30th. They might be 2 or 3 days after the 30th still trying to move all their stuff out. to their new location or whatever. Y'all, that's what they call a holdover tenant. Y'all, those things are going to happen. Y'all just be prepared for that. Y'all, and chances are it's because y'all the tenant that's moving out, they may not be able to move into where they're going until the 1st, right? So y'all, you got to work with tenants. What I'm saying. Now, if they stay there after the expiration, they still owe rent for however many days. But y'all, you need to just expect that that tenant is going to be held over for at least a few days. And even then, you still got to get the property cleaned up and ready for a new tenant to move in. So my point is, y'all don't sign a lease with the new tenant saying they can move in on the 1st of the month. Y'all, that is not going to happen. I can about guarantee you it won't happen. Y'all, so I'd be looking, in fact, what I'd tell the tenant, let's sign the lease to be effective the 15th. I'll be okay doing that. And if we can get everything ready for you to move in before then we can modify the lease and let you move in earlier. But I don't want to be on the hook for anything, before, say, the 15th of the following month. That way I know I can get the property ready for them to move in. But if you can't, but let's say you put the 1st of the month and now they can't move in. Y'all, that's sort of what they're talking about here. Y'all, you're failing to deliver possession to the tenant. Well, if that happens, y'all, number one, it says the tenant basically has to give the landlord a 5-day grace period. So if we're saying it's going to be ready on the 1st, there's nothing the tenant can do legally until at least after the 5th, because you got to give me 5 days to get the property ready and turned over to you. But if I don't have it ready within 5 days, if the tenant chooses to, they can now terminate the lease and get any monies they put up back. Okay, but the main thing there is they got to give the landlord 5 days. It's kind of like a 5-day grace period for the landlord. But after that, the tenant can now terminate the lease and get their money back if they choose to. Another option they have in number 2, they could actually take you to court and sue you for performance, to turn over possession. Now, if we wind up going to court, and assuming the tenant proves they were promised they could move in at this time, I waited, gave them the 5 days, and I still can't move in. Now here it says the courts may award the tenant an amount not more than 3 months' rent or twice the damages sustained, whichever is greater, plus reasonable attorney fees. So you could be losing 3 months' rent or twice the damages sustained. I would remember that for test purposes, because I will tell you, with the exception of one thing in the Landlord and Tenant Act, and you'll see that here towards the end. But if you ever go to if you ever go to magistrate's court over landlord and tenant issues, whichever side wins, can prove their case. The damages to be awarded is going to be 3 months' rent or twice the damages sustained. So if you can remember that, almost any kind of issue in magistrate's court, I'm telling you, that's going to be the answer they'll be looking for. There's only one time when that's different, and you'll see what that is here in a little bit. But anyway, y'all be careful about guaranteeing possession and then you can't deliver it. Next thing you see here are things we call essential services. Now this is a big deal here. And you see what essential services would include. But just before we even look at them, landlord must provide all of these essential services. No ifs, ands, and buts about it. You must provide these things by law. And so if we look at what these services are, plumbing, sewer services, electricity, gas, assuming it's needed for heating or cooking or something like that, running water, and reasonable amounts of hot water and heat. Y'all, those are considered essential services. Those things must be provided. Now, where I want you to be careful here, and y'all, and by the way, make sure you know what an essential service is. I think that's going to be important to you. But is there anything you can think of in your mind that you think should be an essential service but not listed here? And if you're like me, the first thing that came to my mind was air conditioning. Y'all, air conditioning is not listed here. It's not an essential service. Y'all, according to the law, air conditioning is considered a luxury. Now, heat is an essential service, but air conditioning is not. So I would keep that in mind. That could be useful for you here down the road for sure. But now that we know what essential services are, y'all, here's what the law says about these essential services. And what we're getting ready to look at right here is, y'all, let's say it's winter time and the heat goes out. Y'all, we know heat is an essential service. The law says, tenant, you must notify the landlord the heat's out, and then the law also says, landlord, you must immediately get this heat fixed. Y'all, you cannot let essential services drag out. Y'all, we got to get that taken care of. If the landlord does not comply or does not take immediate action to remedy the issue, y'all, here the law says now the tenant can contact the contractor on their own and have them come out and fix, repair, or replace, whatever we need to do to get that heat going again. But y'all, a tenant can only do what we're describing right here only if it's an essential service and assuming the landlord is not doing what they're supposed to do. But y'all, if it's like air conditioning goes out, that's not an essential service. Tenant, you cannot do what we're describing right here. But here's the other thing you better remember, tenant, or make sure you understand. Y'all, if the tenant makes the call to the contractor themselves, tenant, you must pay whatever it costs to fix the problem. By law, you cannot call a contractor to do any of this work and then tell the contractor to send the bill to the landlord. That you cannot do. So tenant, if you don't have the money to pay for it, do not call the contractor because you're going to have to pay for it. But then in paragraph 3 is where it says, once you pay for it, and again, it better be an essential service, then you can actually deduct that cost from your rent. So in essence, you're getting it back. But y'all, you're going to have to pay for it first, and then you can deduct it from the rent. Now, I think it's like paragraph C in your book, if I'm not mistaken, but you should also see there where it says, under no circumstances should this section be interpreted to authorize the tenant to make repairs on the rental unit and deduct the cost of the repairs from the rent. Y'all, what it's saying there is under no other circumstances can you do this, tenant. Y'all, the only time a tenant can deduct anything from the rent is if it's an essential service and the tenant had to call the contractor and pay for it themselves. Then they can deduct that. But under no other circumstance can a tenant deduct any amount from the rent for any reason. Y'all, even, and I get this question a lot, well, can the landlord agree to let the tenant fix something? Maybe the tenant knows how to fix it, they can do it themselves. So that they just agree that the tenant will fix it and the landlord will allow them to deduct $200 from next month's rent. No. Y'all, you can't agree to break the law. Y'all, the law says you cannot deduct anything from your rent. In other words, tenant, you pay the full amount of rent, and if the landlord owes money back to the tenant, then you're going to have to write him a check back for that expense. But you cannot deduct it from the rent. All right, beat that up. Y'all, next thing you see here, it talks about the remedies for landlord's unlawful ouster. Y'all, say I've got a tenant in my property and say I've got 7 months left on the lease. But now I've decided, you know what, I want to do something else with this property and I can't do it with that tenant there. Well, could I ask the tenant to terminate the lease and leave? Well, yeah, you can ask them. And if they're willing to do that, then that's fine. But if that tenant says, no, I'm not moving. I'm here for another 7 months and I'm staying here. Then landlord, that's it. There's nothing else you can do about it at this point. But what some landlords will do, they will start harassing the tenant or y'all just doing stuff in a way, y'all basically trying to force the tenant to leave. Now, obviously, that's illegal. You can't do that. But if the tenant feels like they are illegally being pushed or forced out, then again, they can take you back to court and sue you for unlawful ouster. And guess what they're going to get from the courts? 3 months rent, or twice the damages sustained, whichever is greater, plus reasonable attorney fees. Y'all, again, you see it, that same penalty. I remember that, y'all, in almost every situation, it's going to be 3 months rent or twice the damages sustained. All right. Now we look at what the landlord remedies are in case the tenant is not complying. And y'all, typically when the tenant's not doing what they're supposed to do, what's usually the problem? Not paying rent or failure to pay the rent. Well, here's what the law says about that. Y'all, if they're not paying their rent, y'all say, for example, my lease says the rent's due on the 1st, then y'all, I have to give the tenant 5 days grace period. You cannot charge late fees or anything like that within 5 days of the due date. You got to give the tenant a 5-day grace period. But if I don't have the rent and late fee after the 5th, now it says I have to basically send a letter. Y'all, I don't think this is important for test purposes, but they call it a show cause letter. But I send this letter to the tenant, basically saying, tenant, you're now in non-compliance with the lease due to non-payment of rent. You now have 14 days from the date of this letter to pay all your rent plus any late fees, again, if we're charging that, or we will begin to have you evicted. Okay? But you got to send them 14 days. And you got to give them the 14 days to pay the rent and catch up. Now, another option would be, if you're looking at paragraph B, you should see there in capital bold letters there in your book, where it says, if you do not pay your rent on time, if you'll put this clause in your lease, then you can do it this way. Where it says, if you do not pay your rent within 5 days of the due date, the landlord can start to have you evicted. You will get no other notice as long as you live in this unit. If I put that clause in the lease, then after the 5th, say, for example, on the 6th, if I still don't have the rent, I can go ahead and have you evicted at that point. And I will tell you, that's the way I've always done it. So really you got an option here on how you can either send them the 14-day show cause letter, or you can put this clause in your lease, and then you can just go ahead and have them evicted first time they don't pay on time. That's the way I like to do it anyway. Okie dokie.